Hello friends, in the series on the income tax cases, today we will discuss a very important issue regarding permanent establishment. Some incomes are taxable in the case of the assessee depending upon whether the assessee has permanent establishment in India or not. The issue in this case was that if the assessee was having permanent establishment in a year, then in that case whether the income of the assessee can be taxed in subsequent years even if the assessee do not have the permanent establishment in those years, or in simple words, whether the criteria of the permanent establishment is to be seen on the basis of year to year based on the definition of permanent establishment in tax treaty. This issue was discussed in the case of Nuovo PIGNONE International SRL versus Deputy Commissioner of Income Tax, and this case was reported in 117 ITR at page number 441. The matter has been decided by Delhi ITAT D bench and the date of the judgment is 13th June 2023. In the present case, the assessee was having the permanent establishment in ACS building, but the assessee vacated this permanent establishment on 1st May 2012. During the assessment proceedings, the assessing officer issued a show cause notice to the assessee that why the amount received from offshore supply connected to the permanent establishment should not be taxed in India. For this show cause notice, the assessee gave a modest reply that the assessee do not have permanent establishment in India, so the proposed income by the assessing officer does not fit to be added in the present facts and circumstances, because the assessee do not have the permanent establishment in the year for which the case is related. But the assessing officer, rejecting the submissions of the assessee, made an addition of 2.6% of the total offshore supply as income of the permanent establishment. The assessee carried this matter to the tribunal. The tribunal said that existence of permanent establishment is to be seen on year-to-year basis based on the definition of permanent establishment in tax treaty. Tribunal said that merely because the assessee has permanent establishment does not mean that the assessee has permanent establishment for the subsequent years also. Tribunal further said that whether the assessee has permanent establishment in India or not, the burden of this thing is on the department to prove that the assessee has permanent establishment in the current year for which the matter is going on. When the department felt that the matter is going out of their hands, they requested the tribunal to remand back the matter to the assessing officer to determine whether the assessee has permanent establishment or not. For this, the tribunal said that during the assessment proceedings, the assessee has submitted all the evidences which clearly suggest that the assessee do not have permanent establishment during the assessment year. So there is no need to improve or to give the second innings to the department to improve upon the deficiencies in the original assessment. In the present case, there was also discussion about the reopening of the cases based on the borrowed satisfaction. For this, the tribunal said that when the information is received by the assessing officer from some reliable source, then the assessing officer has to make the investigation and do the homework, and the assessing officer should not reopen the case by simply cut and paste methodology without application of mind, and the case should not be opened on the borrowed satisfaction. It is the decision of the assessing officer that whether the case is to be reopened or not. Friends, this case is very important as far as the concept of permanent establishment is concerned and as far as the reopening of the cases on borrowed satisfaction is concerned. At the end of this video, once again I am repeating the name of the case. The name of the case is Nuovo PIGNONE International SRL versus Deputy Commissioner of Income Tax, and this case has been reported in 117 ITR Tribunal at page 441. The matter has been decided by Delhi ITAT and the date of the judgment is 13th June 2023. Thank you, friends.